of today's seminar, but I'm ready to give a short presentation about my lessons learned, my experiences concerning the independence of administrative courts and administrative judges under the Hungarian experience connected to the non-introduction of the separate court system. But as you are on the agenda and your titles were already given, I don't want to take the floor as the first presenter. I'd like to give the floor to the first colleague who would like to start his or her presentation. Who wants to be or who should be the first? I don't know what was the order at the last occasion. Who wants to start the?
Well, there is always some program, but I personally I don't have anything against you starting the presentations.
Me starting.
If it is yes.
I think it's a good idea.
Good idea. Then I have to find my PPT. I have to use the small icon, as I remember, at the undock. And no, this is not the solution. I lost all of you. I cannot see anything.
We see you, but we do not see the PPT.
Yeah, exactly.
Okay. How can I give you the picture of the PPT? Which icon should be used?
After the microphone, there is a small, hát ilyen két képernyő van a mikrofon mellett.
Oké, és ha azt megnyomom, akkor?
Enable, igen. Akkor ki tudod választani, hogy melyik ablakot akarod meg sérelni, hogyha minden igaz.
Hát, csak nem ad nekem ilyen lehetőséget.
Nem világít zölden?
Tessék?
Nem világít olyan zölden? Is it green that enables screen sharing for you?
No.
Agata, are you here? Because I think that you should also, because Professor Paty is telling us that he can't enable his screen sharing because it is red for him.
Yes, but it is red because it is turned off. But he has the permission to turn it.
Okay.
So
I see.
He should be able. So
Okay.
Professor, please just click on this button, or maybe if it will be easier for you.
Yes. Okay.
And we can see your screen, but now you have to select the right window with your presentation.
Yes. How? Okay. So.
If it will be easier for you, I can. Oh, okay.
Okay. How can I select the file?
It is just sharing your screen. Generally,
Your screen. You have to open the presentation itself, and when it is open, then you can share the screen of the presentation. So it has to be opened on your computer.
Now I'd like to make it again. That was the. Okay. Now you can see.
Yes, we can.
Okay.
Yes, it is fine.
And you can also hear me at the same time.
Yes,
Is it
exactly.
okay?
Yes, absolutely.
That's the title of my short presentation, kind of summing up of the last weeks or months, thinking about independence of judges, independence of judiciary, which is a sensitive topic in all the countries and also a sensitive topic in the European communities, European Union. I wanted to narrow down the questions to the independence of administrative judges and administrative judiciary regarding the planned but finally not realized Hungarian administrative court system. It was planned and enacted in 2018, as I described it a couple of times before, but finally it was abandoned by the Parliament in 2019. If we would like to talk about judicial independence, general questions occur, and we have to answer the questions of independence from what should be independent from what. It can be understood in three ways, in three areas. The independence of the judge in making a judgment is an overall requirement in all the legal systems under the rule of law, in all constitutional systems. Also, the independence of the court in which the judge is sitting and giving his judgment is also a requirement. And these first two requirements are inevitable when we talk about judicial independence. But the third aspect, the third area, the independence of the judicial organization itself, which is a branch of the state organization, is not so inevitable and not so self-understanding. But in the last 5 or 10 years, the independence of the judicial organization itself forms a crucial part of understanding judicial independence. The independence, first and foremost, means that the judgment cannot be influenced, neither by the parties, neither by other actors, by the state, by the government, and of course by the legislature. It results in a lack of substantive control from other two branches of the political government, the legislative branch and the executive branch. The notion or the understanding of independence is necessarily connected to one of the most important, or we may also say the most important requirement concerning judicial activity. This is impartiality. Judges, courts, tribunals should decide impartially without any bias, and their decision, the judgment should be impartial in all circumstances, and all aspects, requirements, means of independence form a tool, form means in order to ensure the impartial judging or impartial decision making. We also have to find answers to a general question. The general question is the level of independence, if we may use this expression, the level of independence. Are the levels of independence, or the independence is an absolute value of judicial organizations, of judicial decision making? And if we are talking about levels of independence, can we reach a level of complete independence? Does it exist at all? Or we'd better to talk about judicial autonomy, or autonomy of the judicial organization of the courts, which is the right expression. And we also have to ask the question and answer the question about administrative courts and administrative judges, as they fulfill different tasks within the court system of a country. Of course, administrative courts are courts and have to be courts, tribunals under the Section 6, subsection 1 of the European Covenant on Human Rights. They have to be courts like ordinary or other specialized courts. But when we talk about their nature of being courts and their nature of being judges like other courts and other judges, we also have to notice that the task that administrative courts fulfill, the function they perform, is strongly related to the administration of the state. In each and every administrative case at the court, the decision affects the capability, the capacity, and the capability of the executive power, the capability or capacity of administrative state organs. These judgments not only talk about what is lawful and unlawful, who wins, who loses the case. These administrative court judgments always gives us answers about the machinery and the actions of the administrative organization of the state. If we talk about independence, within the word, we say that somebody or something is not dependent from somebody or something else, but in every state system, in every state organization, there are natural forms of dependence. I call them natural because they come from the nature of the state, the nature of the constitutional system. Concerning this topic, we have to mention that all judges are under criminal liability. Of course, in each and every constitutional system, there are limits on the initiation of a procedure when a judge is concerned in a criminal procedure. But it is possible to start a criminal procedure. It is possible to start an investigation, and after the permissions of an independent body or independent decision maker, the criminal procedure can be started and can be finished, and the judgment can be done against a judge as well. So it is a kind of dependence. The judges are also under criminal law, and they are under criminal liability, and it is possible to start a criminal procedure against them. They are also under disciplinary or ethical liability, and this liability is wider than the criminal liability. Judges cannot behave in any way, either at the bench in the courtroom or outside the bench, outside the courtrooms. Their behavior in the ordinary life is also regulated or affected by ethical codes, and they are under ethical liability outside the courtroom, outside the court building as well. The third aspect of being dependent, I use and I say quotation marks with this word dependence, is the question of appointment and promotion. No judge can appoint him or herself alone to be a judge. No judge can promote himself to a senior position, to a president of a court position. There is always somebody else who decides about the appointment of the judges and the promotion within their career. The fourth aspect of natural forms of dependence is the judges are also employees. They work in the workplace. They do judge, and all judges do work, and therefore they have bosses. They have leaders who can and have to check whether they did the work, the judging work. Somebody has to enumerate or evaluate the judge's work, and someone has to say that you can go to holiday. No one can be him or her own boss or him or her own president. The fifth aspect is that the decision-making powers of the judges and the courts are limited by the law. It is the law enacted by the parliament, proposed by the government or cabinet, and enacted by the parliament, who gives powers to judges to decide cases, and these laws can be modified, can be altered. The different powers of judges can be transferred to other organs or other judicial or non-judicial tribunals. Let me give an example. In Hungary, in the past 10 years, a huge number of cases were transferred to public notaries. we have a notary system where notaries can fulfill state tasks as well, and they can give decisions outside of the courts. Of course, the decision of the public notary can be questioned in court, of course, but it is not the court where the case starts. The case has to be started before one of the public notaries. And of course, as a sixth aspect, it is of course that in all countries it is a requirement that judicial decisions should be there have to be remedies against the judicial decisions. It means that under remedial procedure, every decisions can be reviewed by another court. This is a kind of dependence. If my decision can be attacked by the parties and another court can decide about my judgment, I depend on the result of that reviewing decision. If we talk about the judicial system or judicial organization, we find similar natural or logical dimensions of the dependence. If we talk about the court system as a branch of the state power, court organizations, the organization of the courts is established by law. The law is enacted by the legislature, by the parliament. It is proposed by the government. Court can be established or terminated. It is a dependency on legislator and on the executive power. Or is it a dependency on the legislator or the executive power? We may answer that this is not a dependency. This comes from the nature of the separation or division of state powers. It is the parliament who enacts the laws, it is the government or executive who executes the laws, and it is the judiciary who decides about the disputes, who decides about the legality of state actions and legality of private actions. The same applies to procedural acts, the procedural laws, which include the powers of the courts, and these laws can be and are regularly modified in all states. We may also ask the same question: is it a kind of dependency on the legislature and the executive power? If we answer with yes, this is a kind of dependency, and courts should be independent in the aspects of the procedural law, it would result in a nonsense saying that legislation has no longer any powers to change, to modify the procedural laws. As a third aspect, the budgetary question is overall important. The budget is determined and coverage of it is not provided by the courts. It is not the courts who collect taxes, it's the government who collect taxes. It is not the court who regulate the size, the amount of taxes, it's the parliament. And all kind of state incomes is regulated by the parliament. This is one of the prerogatives of a democratically elected parliament, and it should remain in the parliament's hands. The question of appointment is another aspect. Judges are appointed by someone else, appointed in our system by the head of state, by the president of the state. The heads of courts, the president of the Supreme Courts are elected in our system. They are elected by the parliament with a 2/3 majority of all the members of parliament. Is the appointment of judges, the appointment of presidents, election of presidents, is it a question of dependency, or is it a logical or natural machinery or natural aspect of a constitutional state under the rule of law? The number of the cases is also another aspect. The backlog cannot be controlled by the court itself. It is a result of the number of disputes, the number of debates in a society, in economy, the number of debates against the state. It is not depending on the court's decisions. And I found a very interesting topic about public opinion. in all country, in all modern country with the social media and the normal media, we face that if a crime, typically a crime happens, even if much more if a politician or public person is involved. So if a crime occurred, the public gives its judgment and opinion very quickly. Before any criminal investigation or any criminal procedure started, the public, the social media, the electronic media gave its judgment or their judgment. Someone is guilty, someone committed this crime he or she is accused of. And the courts, from the nature of the working of the courts, give their judgments years later. And if the judgment is different from what the public is expected, it always gives a shadow on the trust within the courts, saying that this and that guy, this and that actor committed the crime, and he or she was not convicted by the courts. Finally, we cannot forget about the parties who take part in the court procedures, and the presence of the parties who take part in the procedures, and the presence of the judges elected councils is also natural dimension of dependence within the judicial system. Let me turn to our reform in 2018 and 19. Who were the key players in the system, and what were the main differences from the ordinary court system? In our country, for more than 10 years, the central management, the task of central management of the court system is vested into the National Office for the Judiciary, to be more correct, to the President of the National Office for the Judiciary. The President of the National Office for the Judiciary is also elected by the Parliament, by the 2/3 majority, for 9 years. He or she has a great number of powers concerning the budget, concerning the personnel, concerning the structure, and concerning the appointments. One of the novelties of the separate administrative court system would have been a correction of that system, saying that for administrative courts, only 9 courts, 8 regional and one administrative high court, it would have been the Minister of Justice as a state body performing the external administration, the external management of the courts. The Minister of Justice today has no powers, no tasks at all concerning the judiciary, but it was not the case before before 1997, as traditionally in the Hungarian system, similarly to more than 20 other European Union member states, it is the Minister of Justice and Ministry of Justice who has management and administration powers. The reform, the establishment of the administrative courts was an attempt by the government to change back the system to the ministerial management. The National Administrative Judicial Council, which is similar to the National Judicial Council, which is a supervisory body controlling today at the ordinary court system, controlling the National Office for the Judiciary. In the administrative court system, a separate judicial council would be created, where the president of the High Court had been not only a member but also the chair, the president of that Judicial Council. As in all the systems and as in the ordinary court system, there are judicial councils in all the courts, in all the bigger courts. The new system would establish judicial councils in administrative courts as well. That would play a key role in the system, working in two separate forms: courts, councils for personal questions and councils for administrative matters. The administrative judges themselves, under the planned new system, the administrative judge would be a separate status. Under the constitution, the modified constitution, under the new laws enacted in 2018, ordinary judges and administrative judges would form the two branches, one bigger and one smaller branches of the Hungarian judiciary. It would be an independent legal status, independent from the ordinary judges, but part of the same law to judges would apply for them. To the transfer applicants, under the Transitional Act, all judges adjudicating administrative cases in 2019 were entitled to apply for a transfer to the new system. It was only half a page of application signed by the judge, and after this application by the judge, it was compulsory. It was planned to be compulsory to get the judge into the new system without any further conditions. And the key player and one of the most important, or the most important key player became the Venice Commission. The Commission analyzed the system, the two laws, the law for separate administrative courts and the law act on the transitional rules. They analyzed it accurately. They went into every detail. Mostly supportive opinion was what the Commission gave, but there were critical elements as well. We now, after 3 years, we know the result. The result was the parliament and the Hungarian government abandoned the plans establishing a separate administrative court. Therefore, we have to ask, were there systemic problems? What kind of problems occurred? We may analyze it from various aspects, and we answer that the new administrative court system would be independent or not less independent as the ordinary court system, having the difference that the ordinary court system is managed by President of National Office of Judiciary. The new administrative court system would be managed by the Minister of Justice. The new administrative court judges regain the same status with the ordinary court judges concerning the immovability, appointment for unlimited period. They would have the same guaranteed salary, but concerning promotion and the nomination to higher positions, the minister would play a crucial role. It was the minister who decided, and the minister who nominated the court presidents, the 8 court presidents, and also the leaders of the chambers within the courts. So the minister was the nominating or nomination authority. As I mentioned, there were planned numerous councils in each court and council at the higher level for the whole system, National Administrative Courts Council or Administrative Judges Council. It has substantive powers, under my opinion, to counterbalance the minister's powers. But concerning the Venice Commission's opinion, the councils giving their opinions either in Council for Personal Matters or Council for Administrative Matters could not play the role of effective counterbalance against the minister's decisions. If we stop at this point or at this moment, we can find an interesting question or interesting problems. What is effective counterbalancing? If the minister is the decision maker and the different councils give only opinions, we may agree or we may say and we may agree that the decision maker, the minister, has the power to decide. The others have only possibility of giving opinion. If we change the system and we say that the effective counterbalancing of a decision-making power requires that the council or other body has to take part in the decision with co-decisional powers, the result is that it is not the minister longer who decides. We then changed the system of decision-making. We then changed the power. We shifted the power from the minister to the council. If it is not the minister who decides about budgetary questions, about promotions, about the management of the courts, but the council is who decides, it results in a system in which the council, elected by the judges, results in a system in which the councils, elected by the judges, administer themselves. This is a kind of judicial self-government. And if we read carefully the Venice Commission's opinion about this system and about other judicially related problems, it turns out that sooner or later, the judicial councils will have to have co-decisional powers, and the systems should be shifted or changed into a kind of judicial self-government. If the judicial councils have not enough decision-making or decision-influencing powers, these systems or the system will not fulfill the requirements stemming from the Venice Commission's values and commitments. What is also an important question, the trust. If a new court system or if any court system is changed or a new court system is about to start its working, it is crucial that the public in general has to have a trust in that new system, and the courts and judges themselves, from the economy, from the governmental actors, and of course from the society. And trust is also important from inside. The judges themselves and the managers of the system themselves have to trust in the new system, have to trust in independency, impartiality, and of course all aspects of machinery and working. It is not widely known because it was not publicly debated at all that 2020 the Hungarian Parliament abolished the administrative and labor courts that started their working only 2012. So after 8 years, these specialized courts were abolished. Not a word was said about it. Of course, it was during COVID times, but the specialized courts, kind of mixed specialized courts, were abolished without any debate. What are the lessons learned? These lessons or these experiences, some of them is not legal or not jurisprudential. Let me stress once again the importance of building trusts. It precedes everything. The planned new system, changes in the planned new system was started and done so quickly that it was not or could not be followed by the public trusts that precedes everything. We have a strong and quite long historical tradition concerning separate administrative court that was abolished, as I explained several times before. It was abolished after the Second World War in 1949. The strong historical tradition alone doesn't solve anything. Especially, this tradition is not followed strictly, or cannot be followed, as the ancient, the old Hungarian administrative court was a single court for the whole country, having no first-level tribunals, similarly to the Polish administrative tribunal started its work in 1922. If historical traditions are used for grounding the changes, but these traditions are not well known by the public today, it can result in a different way. Facts never bother critics. The criticism concerning the planned new system of separate administrative courts was not about the facts, was not about the rules enacted, not about the 8 separate courts and 1 high court planned. The critics were criticism against the Hungarian government, and the separate administrative court system and the administrative judges were only a cause for that criticism. In 2004, when Hungary made its accession to the European Union, a similar court management system was in force. And one lesson is a bit bitter, says that there are solutions that are dangerous in one country. The separate administrative court was deemed to be dangerous for Hungary. It was not good for this country to introduce, and therefore it is prohibited by the international community. But this solution turned to be mandatory in another country. I think of Slovakia, where separate administrative court started its operation, the High Court, in 2021, and separate 3 first-level courts will start their operation in the next year. And the establishment of separate court system was written into the agreement between the European Commission and the Slovak Republic, and this is a commitment from the Slovak government or from Slovak Republic towards the European Commission. So it's prohibited for Hungary, but it was made a part of a contract, part of the agreement for another country. And the final lesson is about Charles Montesquieu, Les Esprits de Loi, the spirit of the laws. When he issued his book and he re-edited it several times, he wrote sometimes that it is not under his will that from his book shorter or longer sentences be quoted, because he deems his book as a whole, as one united work. And the contrary of his will, there are several quotations from Montesquieu's famous book. I think the most important quotation is that state powers should be separated because power must be limited by power. And I think the whole book of Montesquieu was about the limitation of power, the control of power by another powerful actor from within the same state system. If we separate the judicial administration from executive power and legislative power, if we say that it's not the government who and it's not the legislator who is responsible for the external management external regulation of the courts, but it is the judges or the judges' councils that has to regulate, that has to decide. It will give more and more non-judicial but executive and lawmaking power to the courts themselves, changing the separation, changing the division and allocation of powers within the state. If we make too powerful, if a system makes too powerful the judicial councils or judicial administrations, judicial self-governments, it could result in a non-balanced system within the state power. That would be the final lesson, and I only can hope that you are still here. And I thank you for your kind attention. And now I'm trying to get my picture back. I close this one. Thank you very much.
Thank you very much, Professor. Gabor was in the next, but I didn't see him. Oh yeah.
Gabor.
Yeah. Hello.
Hello. I was here just I had also some problems with the Wi-Fi, so rather turned off my screen to be to hear everything and to be here. Yes.
Floor is yours.
Oh, thank you very much. Then I will do the following thing. I will try to share my screen. This is the presentation. Do you see it? May I ask?
Yes, you see.
Yes, you do see it. Okay, thank you very much, and I'm very happy to be here, and also I'm very glad to hear the presentation of Professor Patyi, which was quite a comprehensive, a complete presentation on the issues of the Hungarian system of judicial of administrative judiciary, because it is really an important question and really an interesting question, and I think that he's quite an expert in this matter, also by his experience, his personal experience on this matter. As to my presentation, I would like to jump to some conclusions and a little bit to summarize my research in the research group, and to conclude the two basic search or research area which I was invested in the last half year, and a little bit a continuation of my presentation of the Warsaw Conference. Basically, as you know, my research was divided into two parts. The first was dealing with the administrative, with the judiciary activism of the Court of Justice of the European Union and the relation of national or member state regulations and member state court decisions. And the second part was dealing with the effectivity or the creation of the Slovak Supreme Administrative Court. If we go to the first part of the research and the conclusions of the first part of the research, the baseline is that there is a division between the Court of Justice of the European Union and some of the highest courts in some member states on the interpretation or the position of the EU law, because as you know, and I was having presentation on this several times, as you know, the Court of Justice of the European Union position is that the primacy of the EU law is absolute and unconditional, and a lot of decisions of the Court of Justice of the European Union are tending towards this, but not every time or not in every case is accepted by the member states' constitutions or the Constitutional Court in several cases also by the Supreme Administrative Courts. Although I must add, the administrative organs and the Supreme Administrative Courts are a little bit worse position than the Constitutional Court, as the Constitutional Court reviews the constitutionality of the legal norms or normative acts, while the Supreme Administrative Courts or the administrative judiciary or the administrative organs or the organs of public administration usually has to be apply or they interpret the legal regulation also concerning the EU regulation and the constitution. But there can be some divisions, and there were some experiences. There were some cases, some court cases which were presented during my presentation. The first was if you remember, the Czech tax case on VAT, value-added taxation concerning tax refunds and tax control, which was in the end dealt with the change of the legal regulation. So the Czech tax law Czech tax regulation was changed. But there were also some other cases which were quite interesting. Matrimonial cases in the Czech Republic where the matrimonial office refused to register two parents of the same sex for a child. This was a case in the Czech Republic, and also this is also in connection with some constitutional values or some values which are declared in the constitution. In the end, this case also ended with the change of the legislation, and the matrimonial registry at the moment is changed or contains not the father and the mother of a child, but the parent one and parent two of a child. So this is also a change, or this is also a matter of fact which the organs of public administration should deal with. So there are cases, several also in the Czech Republic, in Slovakia, and last year or this year in Slovakia there were basically two very interesting cases which are dealing also a little bit with values and sovereignty, or maybe sovereignty of the member states. Namely, in the Slovak Republic, there was a case of an asylum seeker. There were one Slovak citizen and one foreigner. I think he was from Southern America, if I recall it correctly. And the foreigner sought asylum based on family reunion, because they were of same sex and they were married, two men to each other, and the Slovak regulation of in these cases, in these asylum procedures, did not had this clause, but the administrative court decided that it is discriminative and it should be allowed. And the latest case was also decided by the Supreme Administrative Court. It is also dealing with the matrimonial office in the public administration, where a biological man wanted to change his gender or sex to women, to opposite side, but without a surgical procedure. So the matrimonial office declined. The court on first instance declined also the apply or this change or this registry. But the Supreme Administrative Court told that there are no documents or there is no legal regulation. There are no provisions of the law what documents should be required to provide this change. So it reversed the decision of the court of the first instance. So it will go on further. So it is quite an interesting thing. But this shows also the relevance of the constitutional values, the relevance of the society's values, which are implemented or which are in the constitution of a given state, that they can truly influence the work of the bodies of public administration. They can truly influence the work of administrative courts. But usually it is connected with some at the moment, as I see, usually with the traditional concept of family, sometimes with child protection issues, and also tax issues or asylum issues. So as to my conclusions, and there I would like to make a little bit of a greater stop because as we were also discussing this matter in Warsaw at the conference, and there is also an important thing which should be mentioned in this matter, and that is that we can approach this problem from two sides, in my opinion. One, that we try to create a hierarchy of norms of the European Union and the member states, or we try to make some proposals for interpretation. But during my research, I realized that whether a member state is absolutely opposed to the opinion of the court, I mean the Court of Justice of the European Union, or somewhat accepted its decision, there is always a core which is untouched by the law of the European Union, or as I see, there is also a core, and this deals with the basic sovereignty of the state, and this is outlined very detailed in the decision of the Polish Constitutional Court from October 2020, where the Polish Constitutional Court, in my opinion, in a quite reasonable and quite detailed way defines the boundaries of the Polish Constitution and the EU law. And there are quite interesting statements of the Polish Constitutional Court, or in my opinion, there are quite interesting statements in this matter regarding this matter. I would like to pick out some. I would like to cherry pick with among the statements because truly I think there can be consequential also, not only for Poland but also for other Eastern European and post-socialistic member states. So the one and a very important opinion of the Polish Constitutional Court is that international treaties, such as the Treaty on the European Union, are in the hierarchy below the Constitution, given that the Constitution is at the top of the Polish legal hierarchy. So this is the baseline of the decision of the Constitutional Court. This is the origo of the thing. And also states that the examination by the Constitutional Court is limited only to determining the content of the rules and their compatibility with the Polish Constitution. So the Polish Constitutional Court deals with the Polish Constitution, which is rather self-explanatory, and also declares that the Court of Justice of the European Union retains an exclusive competence to interpret the EU law. But the Polish Constitutional Court has the final say in determining whether specific rules, including EU law, are compatible with the Polish Constitution. So there is a definite and a very clear line where the Constitution starts and where the EU law begins, if I may say so. And then it is pointed out in the decision of the Constitutional Court that because it was on the Prime Minister's motions, that the Prime Minister's motions concerns with the relationship between the treaties and the principle of primacy of the Polish Constitution. That means that essentially with the Polish, with the sovereignty of the Polish state, the Polish Republic. So this is very interesting, because the question of sovereignty also is implied by the Czech Constitutional Court, by the Slovak literature, or the Romanian Constitutional Court. So we can see the concept of sovereignty is a core concept when dealing with the relation of EU law and member state law. And also a very interesting statement or interpretation from the Polish Constitutional Court is that because it deals also with the competencies conferred to the Union, That means that, and in its opinion, means that no member state exercises its sovereignty in absolute sense, because there are some competencies conferred to the EU as the recipient of these competencies, but also it has to be respected that every member state has its national identities and constitutional identities, and the framework provided by the principles of proportionality and subsidiarity has been under the Treaty of the European Union has also been accepted. And it was also stated that there is no doubt that the member state as sovereign parties of the treaties has not empowered the EU bodies to presume powers and derive new powers from existing powers. So it is very important that the principle of cooperation, the principles of subsidiarity, basically the Article 1 and Article 2 of the Treaty of the European Union should be interpreted restrictively or in a restrictive way, because this is one of a major sign of the EU or the working of EU bodies, that they cannot by interpretation gain more competencies than it is laid down in the treaties. And also it is very important to point out that the Constitutional Court stated that the Polish judiciary is part of the Polish constitutional identity, and therefore it is part of the Polish sovereignty as itself, and basically these were the most important reasons, which or most important statements from the court. And I would like to add one more thing, reflecting also to Professor Paty's presentation, who was talking about the independence and impartiality of the judges, because it is very interesting that the Polish Polish Constitutional Court is telling that the rule of law does not determine the appointment method of judges, but requires their independence and impartiality. But impartiality and independence is linked to a specific case in which the judge is sitting. So it is in the, if I see it correctly, in the concept of the Polish Constitutional Court, the independence of the judge, of a concrete judge, is always related to the case which he is deciding, or which he is deciding. That is an interesting concept, because Professor Paty was talking about a broader concept, a complex concept in this manner. And this was mostly the first part, or these were the conclusions of the first part of my research. And the second part, I dealt with the questions of the Slovak Supreme Administrative Court of the Slovak Republic, which is a relatively new, as I told it several times, and after some consultations also with judges from the Supreme Administrative Court, there were basically two major points defined during the research. That one is the question of quickness. I dealt with electoral cases, and I told also in Warsaw that they were in a 30-day term. That these had to be decided very quickly, the communal cases of communal elections. When I came home to Hungary, then I received an information that this 30 days has been changed to 90 days because the court realized that the 30 days will be too short of a term to a proper supervision of the municipal elections, which are ongoing thing at the moment in Slovakia. But the basic, if we are talking about this question, or the question of quickness of speed, the basic question for me is that if speed can be an obstacle to a lawful decision, and if so, to what extent. This was one thing which I was dealing quite a great deal with it, and also the question of legal gaps. I gave an example of the supervision of legality of municipal ordinances in Slovakia, where the question was that what happens when a normative administrative act is abolished, but based on this abolished normative administrative act, an individual normative act was issued or were issued, because the review procedure of the normative and individual acts in Slovakia are separate procedure, and there is no provision of the Slovak regulation to deal with these issues, especially in the case of municipality ordinances. And the question or the basic question in case of legal gaps is that what freedom of action can be granted to administrative courts to fill these legal gaps, and these were the questions which I was dealing with during my research. And in the end, there is nothing else to say for me in this matter. Of course, there will be publications and there will be our reports on our research topics. But as it is the last presentation or last online meeting for us, I would like to thank you for a very, 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 very fruitful cooperation during this half year. It was really great. It was really great to see you also in Warsaw personally, and I really hope that we can go on with this cooperation also, not in this form, in the form of the Polish-Hungarian Research Group, but also in other ways, and also because I think that we will not see us until Christmas. I wish you a very Merry Christmas. Thank you for your attention.
Thank you, Gabor. Thank you.
Thank you very much. Dr. Mateusz is with us.
Yes, I am with you.
Okay.
When the order is, I could remember is next is a Kitty Polak. Kitty, could you start? Or
Yes, I am trying to share also my PPT.
We see your screen and your PPT also.
Okay. Just one moment. Oof. Sorry. Okay, just 1 minute. So, good afternoon. Okay, do you see my PPT?
Yes, of course, we see.
Yes, I have a problem. Okay, so good afternoon. First of, I would like to note that my today's presentation will have two angles. I would like to first give a few of my conclusions regarding the regulation of administrative court procedures with comparative aspects. And secondly, I would like to finish with some special question, a dilemma regarding a special judicial review procedure, the electoral procedure. After my researches, which I have conducted in this research group, I would like to only highlight few of my similarities and differences which shapes our administrative justice system. First of all, let's see the similarities. In Hungary and in Poland, there is a quite similar way, a constitutional background of administrative judiciary. The both the Hungarian and Polish constitution regulates as the background of administrative judiciary, the rule of law clause, the right to good administration, the right to fair trial, the right to legal remedy, as well as that the court's tasked to decide on the lawfulness of administrative decisions. Both of the countries has actually a specified code on administrative court procedures, even though Hungary is not so old. It entered into force only in the 1st of January 2018. After the analysis of the Polish and the Hungarian code, I would not only highlight a few similar rules which helps to accelerate the receiving of the final decisions of administrative court procedures. As we have all discussed, that the acceleration of administrative lawsuits is always a current dilemma. This is also a very important important question, and this was a very important question during the codification of the new Hungarian code. I strongly believe that one of the most important parts of judicial protection for citizens is how quickly they can receive the decisions from the court. And to promote this, the Hungarian code introduced several new elements, some of which are also known in the Polish regulation too, and I only highlighted few of them in my PPT. As you can see, both in the Polish code and both in the Hungarian code, very, very similarly, we find codified the different installation of court powers, the primacy of proceeding in council, that the court decides without hearing, and there's a possibility. And there is the possibility of settlement, mediation, and simplified procedures. Meanwhile, we can find some elements which is not mentioned in the Polish code and that therefore could be considered to regulate, and this was a novelty introduced in the Hungarian code, which is also mentioned in the PPT, is that the model cases, model action can be used, which I already presented in September. I would also like to note few of the differences between the Hungarian system and the Polish system regarding administrative justice. I examined these differences in detail in my previous presentations, and I think from these differences the most lesson can be taken both regarding Hungarian to Polish codification too. One of the biggest differences regarding administrative judiciary is the organization of court system. As it was already mentioned today, in Hungary, ordinary courts decides in administrative cases. Meanwhile, in Poland, independent administrative courts exist. Meanwhile, both countries have a code on administrative court procedures. I see quite big differences in the scope of this code. The Hungarian code understands administrative litigation wider than the Polish code. For example, if we regard the question of administrative contracts is defined in the Hungarian code, and administrative litigation is also considered as disputes regarding administrative contracts. Sorry. In Hungary, also, when the nature of the case arose, it and the facts are qualified, the court has an opportunity to change, to modify the administrative decision that violates the law. Thus, this is facilitating the settlement of the legal dispute as soon as possible. Opposite to this idea, the general idea behind the Polish codification was that administrative courts will not replace public administration in decision-making process. Therefore, the amendment and the modification of decisions is not a real possibility. I would like to also note, without getting more into detail, that our legal remedy system against administrative court decisions are also quite different. Okay, sorry. In my last part of today's presentation, I would only like to present one special dilemma regarding the special administrative procedure, the election procedure. In my presentation in November, I already presented a similar slide regarding the similarities and few of the differences of the Hungarian and Polish regulation on elections. I would like to note that in Hungary, all the different elections have their special rules codified in different acts. Meanwhile, there is a general rules on election procedures in another act. Legal remedies in electoral cases are specified in the Act on Electoral Procedures. There are 3 legal remedy procedures which can be used in electoral cases: the objection, the appeal, and the judicial review. Regarding the judicial review, the Court procedure regulation is quite complex, as I already analyzed it, and this complexity also raises some questions. For example, what we already discussed, that can an administrative court procedure be suspended in an electoral case? Lastly, in my today's presentation, I only wish to highlight one more question related to the territorial scope of electoral cases. This question raised in spring 2022 in the national elections. The background of the case was that in Romania, a few papers were found in a city next to a city in the garbage, which could be related to the Hungarian national elections. The papers seemed like, but not to prove to be postal votes. This is very important. And this situation was attacked in front of the Hungarian National Election Commission. The Hungarian National Election Commission said that the territorial scope of the Election Act is regarding Hungary, therefore they do not have the power to decide in this case. The applicant went to the court against this decision of the Election Commission, and the court made it clear that the jurisdiction of the Hungarian electoral bodies does not extend the education of the legal violations affecting elections in Hungary. There is not a possibility that electoral bodies could decide in this special case. We shall also note that there are several guarantees in the Acts on Elections regarding the voting system by post, which aims to eliminate the possible violation of law and abuses. But after the elections in summer 2022, the Act on Elections were modified as follows. And currently the Act states that the Election Act must be applied in Hungary and outside the territory of Hungary in the election of members of the parliament, etc., in other elections. This modification of the Act makes it clear that the Hungarian National Election Commission have the power to decide in cases not only committed in the territory of Hungary, but also to investigate and decide on legal violations related to elections committed outside of Hungary. In my point of view, this could and I think it will raise several questions. For example, in most of the electoral cases, what we already discussed, the decision shall be taken in 3 days. And the suspension of the procedure is not exercised in these cases. Other countries' procedure could be longer than 3 days, for example, if an information is needed from them. Regarding this case, what I have mentioned, I strongly think there is another possibility to solving this dilemma, which could be that the voting system by post could be regulated in more detail, with more guarantees could be specified. This is the last dilemma I wanted to just mention, and thank you very much for your attention. As this is the last meeting, I would also like to deeply thank you to be part of this research group, meeting you with person and discussing lots of questions in person in November. And thank you very much, and I also wish you a very Merry Christmas, and I really hope to see you soon. With Agata, we already discussed that she is coming to Hungary in spring to the University of Public Service, giving lessons. So I am hoping to see her soon, but also all of you. Thank you very much.
Thank you very much, Kitty. Thank you for your interesting comparison of Hungarian and Polish judiciary system, administrative courts. Okay, we have the next member of our team. Agata, could you start?
Yes, of course. Just I think I need a few seconds
Okay.
to show my presentation. And yes, few seconds. I hope that not more, because my computer stopped working now. Can you hear me?
Yes, we can hear you, but we see that your
Yes, we do hear you clearly.
But I think your photo is frozen.
yeah. Agata?
We do not hear you anymore, or at least me.
Okay, it seems that my computer started to work again. I'm very happy, and I would like to show my presentation. I think that I need just a second. Can you see my presentation?
Yes, we see your presentation.
And that's the way you can see it's fine. Yes, because I wanted to show you my full screen, and it is okay.
Yeah.
So let's start. As it was said today, sometimes we have to finish our research, and it is also, in my case, I would like to talk a little bit about the summary remarks regarding provisional measures. And when I decided to choose that issue, I just wanted to come back to the legal basis I occupied at the beginning, just after the finishing the study, and I wondered what I will find now, and after more or less 20 years, so 20 years later, the issue looks a little bit different than it used to be. First of all, talking about, let's say, basic issue, as a rule, a compliant to the administrative court has not a suspensive effect, and it is the solution that is in Polish law, but it is the solution that it is widely accepted. I'm not talking about only the European law, but if we will go outside the European Union, we can find solutions like this. And the lack of a suspensive effect results from many reasons. And the most important one is that the decision that was issued by the administration need to be implemented. So, for example, if I didn't pay taxes and administration said that I must pay them. So even if I don't agree with that decision, if I go to the court with that decision, I have to pay taxes unless it is possible to obtain a temporary protection. And why it is important? It is also important, the lack of suspensive effect. It is also important that the compliant doesn't use the appeal to court to postpone, to delay the enforcement of the decision. So it prevents a compliant to the administrative court from being used as a means of postponing the implementation of the obligation imposed on the party. But if we have such regulation without any exemptions, it is not the correct solution. So first of all, what does it mean, the execution of an administrative act? It means that some way we are causing that the state of affairs, so the situation that we are observing now, it is consistent with the decision contained in the given act. And how it could happen? It can happen voluntary or in a using the procedure of administrative execution. And suspension of the performance of the challenge act or action is one of the essential conditions for the legal effectiveness of the individual rights. Why it is important? Because sometimes when we will enforce, if we execute the decision, it causes some kind of damages to the compliant, and the effect of such damages can be irreversible or can be reversible, but the consequences that will be difficult to reverse either due to the legal events like taking civil law actions, administrative law actions, or actual. And that's why we need, in some circumstances, to grant to the compliant the temporary protection. And it is as a rule. As a rule that we don't have such suspension, but sometimes we need, and we give that protection. And when the most interesting surveys, scientific surveys began, in that point you can see on the slide, because sometimes legislator introduces various types of modifications, let's say kind of exemptions to that temporary protection. So sometimes by law, we can observe the exclusion by law, the possibility of suspending the execution of the challenged administrative act. And when it happens, looking at the Polish law, I concentrated on the part of the law that regulates the investment process. And we have different types of investment. Many of them are so-called public investment, or investments that are important for the state development, for the public regional development. And sometimes our legislator, I should now say, used to exclude the possibility of granting temporary protection in that kind of procedures. It find out that there were some, it's not one case or two cases, but it was more than 8 different acts that introduced such kind of exclusion. And what else? Sometimes you can find the imposition by act of the rigor of immediate enforceability for a specific type of administrative decision. So this is a different way that interfere with the possibility of obtaining temporary protection. It is said in doctrine, in administration judgments, that if the imposition of the rigor of immediate enforceability is in act, it can't be delayed by the administrative court judgment. So it is quite strong instrument of providing, of giving the let's say green light to the execution of the decision. Why? Usually, once again, it is because of the state reason, like kind of development. And then we have the imposition by administrative authority, the rigor of immediate enforceability for a specific type of administrative decision. And the last modification is important because when the rigor is imposed, it means that we can execute the decision even if it is even if the administrative procedure is not ended. I mean, after the after the decision was issued by the administrative authority, and even before it was challenged by the administrative authority that supervise the administrative of the first instance, as usually it is said. So we have different procedures that modifies that can avoid the main party of obtaining the legal protection. And of course, when we are talking about temporary protection, the first question is how the administrative judgment is organized in the country. So, if we want to trace, if you want to analyze the instrument, the different kinds of temporary protection, we in the first step we have to look at the administrative courts, how it is organized, and then of course it is the issue of a legislator to grant such temporary protection, but at the same time to obtain a kind of balance that on the one hand we need to have enforcement of the procedure, so the lack of the suspensive effect, and on the other hand we have to have the possibility to obtain temporary protection. So types of temporary protection measures available in proceedings before an administrative court are determined by general protection solutions adopted in a given country in connection with the activities of public administration. And the issue that actually haven't been changed for 20 years is the feature of the decision that can be executed, enforced. And we can find in administrative judgments, we can find it in doctrine, many opinions that differs. And sometimes we can find a different opinion on one particular decision. And according to one judgment, it can be executed. It means that temporary protection can be given in such particular situation. And on the other hand, we have administrative judgment that brings the completely different opinion. So the decision can be executed, and it means that the temporary protection can be in that particular case given. What is the solution? The solution is to think about the most wide interpretation of the decision that has a feature of being executed, because in my point of view, we need the temporary protection that is effective. And what does it mean? That protect the interests of the compliant in the most wide possible way. And here the first space for changes in Polish law opens. It consists that through the intervention of legislator, the temporary protection should be granted in relation to those administrative acts whose suspension of executions is inadmissible for formal reasons. Why such observation? Because once again, this observation arose from the field of investment procedure. As maybe you know, our investment procedure is divided into some steps. Each step is ended by different administrative decision. And according to the many judgments, also opinion of scientists, the decisions that are taken at the first step, the second step, so before the last decision, can't be executed. Why? Because they are kind of decisions that doesn't make any changes into reality. And it sounds a little bit strange, but such situation was in Polish law for many years. And what changed that situation? It was a European Commission that said that we understand the feature of enforceability in too narrow way. And after the negotiations that took place almost 10 years with a European Commission, our legislator finally decided to change the acts that refer to investment procedure, many different acts, in order to ensure temporary protection to the decisions that are taken during the investment procedure. So at the end, it was possible, but due to the formal reasons, for many years in Polish law, such temporary protection weren't given. And what said the European Commission when during such negotiations? First of all, it observed that we have too frequent application of statutory restrictions on the basic procedure, like a possibility of obtaining temporary protection. So we can't provide, we can't enter into our Polish system the acts that are excluding the temporary protection as such. So what we need to look at the reasons to grant temporary protection case by case. We can't exclude by acts, so we can't have a kind of general way of excluding. And as I said at the end, we have we did the work, and our legislator, responding to the Commission's doubts, reviewed the applicable legislation in terms of restriction on temporary protection. So it can be done at the end. And one of the example of the lega ferenda proposal. So the possibility, the introduction to Polish law of the admissibility of suspending the enforceability of the Challenge Administrative Act ex officio by the court. Now, temporary protection can be given by the administration, and when the case is sending to the court by the court, but we need a statement from the party. And in my opinion, there is no reason that the court can act by its own. So if there are arguments that can be found in the file of the case, and when those arguments show that such kind of protection should be given, court can should have the possibility to act ex officio. What I found in the documents, and I was quite surprised, some said that it is not a good solution, and they explain in that way that granting temporary protection ex officio, so by the court by its own initiative, cannot be treated as an attempt to mitigate the negative effects of the length of the administrative court proceedings. Of course, it is true, especially when we look at the length of the court procedure, but I think that this argument is not justified. I mean that when we are talking about temporary protection and the negative effects that can be avoided to the party situation, we have to choose the better protection of the party than the let's say a kind of imaginable argument that might not be true. So that is all for my part. I'm very happy that I had the possibility to share with you my research, my presentation, and thank you for the wishes and Christmas wishes. And I would like also make wishes to all of you. Thank you.
Thank you very much, Agata. Thank you for your presentation. And now it's time for my presentation because Przemek is absent. I should try to. No, not that way. So this way I should. Do you see my slide, VT?
Yes.
Yes.
Thank you. Thank you. I will talk about some conclusion. A few months ago, I was very enthusiastic to the idea of electronic court, especially in administrative procedure and administrative court proceedings. But after this last few months, not so much, because I'm more realistic than a few months ago. Why? Electronization of court administrative proceedings and automation of consequences areas of action before the administrative courts are an element of constant improvement in the way it functions, especially in terms of the speed of court proceedings. Many scientists, many writers, judges say that one of the main problems of the Polish justice system is precisely the lengthiness of proceedings before courts, especially in common courts, but also in administrative courts. However, the issue of efficiency of the judiciary cannot be looked only in the context of the quicker resolution of cases. This issue must be analyzed in the context of the subjective right to a court, which is the starting point of any assessment of the action of the judiciary. Thus, the right to a court, expressed in Article 45.1 of the Polish Constitution, would also derive, for example, from Article 6 from the European Charter of Human Rights. Is the foundation defining the principles of the functioning of the judiciary. As Pogonowski submits, the essence of effective justice is the right to the fair and just proceedings before the court, and the possibility to enforce the outcomes of the court's action. In the case of administrative courts, attention should also be drawn to another element of the principle related to the rights of the courts, namely the function of control exercised over public administration. This function is an element of the right to court, is also an important element in terms of protection of the rule of law and implementation of the principle of legalism addressed to public authority entities. The review of an administrative act or inact of a public authority body by an independent, impartial administrative court within a reasonable time is often a great importance. The speed, efficiency of a judicial decision plays an important role in the assessment made by the public, also by a party in a dispute with public administration. It seems that it is precisely this efficiency that is perceived and criticized more than the judgment itself, stating that the action of the public administration were in accordance with the letter of the law or not. The efficiency of judiciary consists not only of elements related to judiciary and its organization, but in structural and procedural terms. Also important are such elements as the quality and stability of the law, the effectiveness of its enforcement, the achievement of the objective and function of the judiciary, and above mentioned perception of the operation of the courts by the parties to the proceedings and the general public, the society. A broad understanding of the efficiency of the judiciary clearly indicates the multifaceted and multi-stakeholder nature of his principle. Those responsible for an implementation of the legal obligation are both the judiciary itself, which includes inter alia the administrative judiciary, as well as, for example, those responsible for the lawmaking process and its stabilization. Also, the executive administration responsible for supporting the management process of the judiciary must contribute to increasing the efficiency of the administrative courts. For example, the proper allocation of funds or introduction of solutions of a technical and IT nature to the courts. Moreover, the electronification of proceedings and the extensive computerization of procedural activities is only one element of improving the efficiency of administrative courts. This statement is all the more important because administrative court, which exercise control over public administration, operating in a certain organizational and legal system. They are not able to simply improve their efficiency in the sense of speed of proceedings. In the situation of, for example, common functioning of the paper system of administrative files created in the course of administrative proceeding before bodies of the first or second instance, are subject both in the material and procedural aspect. Assessment by an administrative court. In other words, the electronization of administrative courts files does not make sense or will be significantly hampered in a situation where a public administration continues to function in the paper age. On the other hand, it should be remembered that the top-down introduction of a mandatory system of electronic proceedings, including digital administrative files, is a situation where the 30% of users still fill in application and other letters by hand so far, will not speed up the proceedings, but will even prolong them. For example, in last week, the administration of process of investment have idea that every procedure before the local and regional administration of investments from the buildings should be made in electronic form, and this 30% are papers, documents are made by hand, not even by computer, but by hand, by writing. So it could be a little a challenge to change the the people who not only the architect, not only the designers or lawyers who work with investors, but common people who try to build some small houses, and they don't take assessment for the designer or from the lawyer. In addition, it should be borne in mind that there is still a high percentage of citizens who do not use IT system, allowing efficiency and effective use of these technologies. In the case of the introduction of IT solution allowing for the remote contact to action, including participation in the hearing at a distance, the issue of digital exclusion becomes even more important. And the legislator and the judges need to remember this situation. Therefore, when assessing the effective of administrative courts in the context of the implementation of the right to a court against the background of the electronification of the administrative court process, all elements comprising the right to a court in this constitutional understanding should be taken into account. In the same time, digitalization of individual elements of administrative court proceedings must be coherent with the electronification of administrative proceedings. Moreover, the digitalization of public authority alone in the situation of high instability of the public law will not allow to use the full potential behind the automation of the operation of courts and administration of or the use of algorithms in the process of law application. The short experience, the functioning of administrative courts with the use of elements of the electronic process allows a preliminary statement that we are, as a state, only at the beginning of the construction of an effective electronic administrative court. In principle, the adopted solution should be assessed positively. However, they also require some correction, especially in the aspect of securing the right of the digitally excluded individuals. A major concern is the relocation of the judicial community to use remote hearing, which was clearly shown by the result of studies from the period of functioning of administrative and common courts in the era of the SARS-CoV-2 pandemic. I don't know, in last month, or I showed that nearly 98% of hearings was not in the official open hearings, but in cameras closed hearings. So even if we have the act who create situation that we can use online open hearings, the judges don't use this solution. So we need to some correction of Polish administrative court procedure before administrative courts act. To incomprehensible predominance of in-camera hearings over remote hearings calls of reflection on the direction of legislative and organizational challenges in order to fully exploit the potential behind the new remote communication technologies and significantly improve the efficiency of the judiciary. I think that this situation, this experience showed that we start the road to the electronic court, but we not prepare the people for this. We try we open new solution, electronic solution, but the people in administrative bodies, in administrative court, and even in private companies don't use effectively this solution, electronic solution. So it is a long and not so quickly way to effective electronic administrative court. And so why I'm not so enthusiastic like few months ago when I start to read and check this my idea of my researchers. I would like to say thank you for your participation of the Polish-Hungarian research platform. It was our last meeting. Thank you also for the participation of our friends from Ukraine, Croatia, and Slovakia. I saw Professor Oksana and another professor, but I didn't see her, but never mind. Thank you for all of the members for the opportunity to familiarize yourself with the research results during our monthly meeting and the substantive discussion, especially during November in Warsaw, where we meet together from some parts of us. And this discussion was very interesting, and we can improve our research in the next steps. And I would like to wish you a very happy Christmas. May you spend it with your family and friends. May we have time to ourselves, not only for the job from the court or university, but for us, for ourselves, for families. And all the best for the new year. If we have some question or no, I didn't see any questions. So see you in next meeting, maybe in next year.
Hopefully.
Possibility, maybe in Budapest. I heard that Agata will go to Budapest in spring. So maybe so maybe in Budapest, maybe in Warsaw, in another place. We have a contact, we have emails, so we can contact each other by this, but by internet if we have some new ideas and we would like to discuss. Thank you very much, and
thank you.
Thank you very much.
Merry Christmas to all of you.